Hello all, welcome to Legal Talks by Desi Kanun. I am Suyash and I am excited to have started this show. On today's show, we will talk about another judicial pronouncement by the Honorable Supreme Court of India in relation to homeopathy and its relevance in COVID-19 pandemic. The case that we intend to discuss today is Dr. AKB Sadbhavna Mission School of Homeopharmacy versus Secretary, Ministry of Ayush and others. In this case, a question arose before the Supreme Court of India as to the relevance of homeopathic system and medicine for the treatment of COVID-19. Let us understand the same. The brief facts of this case are that on 6th of March 2020, the Government of India issued an advisory relating to usage of homeopathic medicine and Ayush medicine systems to all the states in relation to the ongoing pandemic of coronavirus. The petitioner in this case specifically pleaded that state of Kerala did not take steps to implement the above mentioned homeopathic advisory dated 6th of March 2020. Further, the petitioner also pleaded that the homeopathic system would have been able to control the spread of COVID-19 through its immunity boosting medicines, and had it been distributed earlier, the COVID-19 disease would not have spread like it has today. Thus, contending all these aspects, the petitioner sought the following relief. He sought for issuance of a writ of mandamus or any other writ directing the state of Kerala to ensure that homeopathic practitioners are immediately allowed to perform in accordance with the advisory dated 6th of March 2020. What is this homeopathic advisory dated 6th of March 2020? It provides that certain homeopathic medicines could be taken in consultation with qualified Ayush physicians for prevention, prophylaxis, symptomatic management, and as an add-on intervention to conventional care. Thus, the homeopathic medicine was allowed to operate in all these fields. In order to further understand this case, we must look into Regulation 6 of the Homeopathic Practitioners Professional Conduct, Etiquette and Code of Ethics Regulations 1982. Regulation 6 stated that any form of advertising by homeopathic practitioners is unethical and they should not allow any other person to advertise in a manner that may result into self-aggrandizement. The other regulations of these 1982 regulations stated that the homeopathic practitioners are not allowed to publicize themselves by publishing cases or letter of thanks from patients in non-professional newspapers or journals. Now, what were the observations by the court? The court looked into all these regulations, all these advisories, and said that the homeopathic medical practitioners cannot advertise that they are competent to cure COVID-19 disease. And they also said that homeopathy does not cure the disease, but it cures the patients. Thus, the court made a very important point that the homeopathic practitioners can in no way advertise that they can cure COVID-19 disease. And the court also made an endeavor to help the people understand that the disease cannot be cured, but the patient can be. The court also said that the advisory dated 6th of March 2020 makes it clear that homeopathy has been envisaged as a therapeutic aid only, and the prescription has to be given only by institutionally qualified practitioners. So even if a person who has completed his degree in homeopathic sciences cannot prescribe the medicines unless and until such person has been institutionally qualified by either the ministry or by any other agency that is competent to qualify practitioners in this regard. Finally, the court made a very important observation in relation to the practitioners of all forms of medicine. The court said that no medical practitioner can claim that it can cure COVID-19. And the court also said that scientists all over the world have been working to fight this pandemic and find a solution to it. So, nobody can claim, and nobody is claiming, including allopathic practitioners. And there is no such claim in other therapies, including allopathy. Lastly, the petition was disposed of by the court by directing that the homeopathic medical practitioners have to follow the Homeopathic Advisory dated 6th March 2020 as well as guidelines in relation to homeopathic medical practitioners for COVID-19 issued time to time by the Government of India. Now, my concluding remarks are that the court did not overstep its jurisdiction or expertise, did not claim that it is an expert on homeopathic sciences. It left this question to be decided by the government. And as all of us know, that there is a lot of confusion prevalent with respect to the COVID-19 disease. In such uncertain times, the number of medical quacks who dupe people is also on a constant rise. Thus, it is a welcome judgment for both the homeopathic as well as non-homeopathic practitioners, since the court has categorically stated that no person can claim that it can cure COVID-19. And in coming to this conclusion, in my humble opinion, the court adopted a scientific approach and rightly said that the claim to cure COVID-19 cannot be made by anybody. I hope that people follow the guidelines issued by the doctors and medical institutions in letter and spirit and do not fall prey to quackery and superstition. So thank you for watching. I hope you enjoyed this stream. Stay safe and please subscribe and follow us on YouTube, Instagram, iTunes, Twitter, LinkedIn, Discord, Telegram and Facebook. Thank you again. Stay tuned.